case briefs, and so much more. LSData's got what you're looking for.
In 2009, the U.S. Court of Appeals for the Fourth Circuit addressed a case revolving around two key federal acts, Section 216 of the Federal Power Act, FPA, and the National Environmental Policy Act, NEPA. The plaintiffs, the Piedmont Environmental Council, the New York State Public Service Commission, and the Minnesota Public Utilities Commission, argued against the Federal Energy Regulatory Commission's, FERC, interpretation of FPA Section 216. FERC claimed the section authorized them to issue permits for electricity transmission facilities, even if the state had rejected the application, an interpretation that the plaintiffs contested. FERC's interpretation led to them amending NEPA regulations, a step they took without consulting the Council on Environmental Quality, CEQ, an obligation required under NEPA. The plaintiffs saw this as a violation of the statute and included it in their legal challenge. The case came before the Fourth Circuit after a lower court ruling didn't satisfactorily address these concerns. The court scrutinized FERC's interpretation of the FPA and its protocol in amending NEPA regulations, and reached a verdict that had significant implications for the Energy Commission. The court found FERC's interpretation of FPA Section 216 to be incorrect, stating that the Act does not grant FERC the power to issue permits if a state commission has actively denied an application under the one-year deadline. Instead, FERC's authority lies in issuing permits when a state commission fails to act on an application within the stipulated deadline or imposes conditions deemed detrimental to the project. In essence, withheld approval was not interpreted to include denial of an application. The court also held that FERC violated CEQ regulations by overlooking its obligation to consult with the CEQ before making amendments to its NEPA implementing regulations. Consequently, the amendments to the NEPA regulations were vacated, and FERC was instructed to engage in the mandatory consultation with CEQ. In light of these findings, the Fourth Circuit reversed FERC's interpretation of the FPA, invalidated the amended NEPA regulations, and sent the case back to FERC for further review. Any challenge to these amendments was dismissed without prejudice, as the court deemed them not ripe for consideration. This ruling stands as a critical check on FERC's regulatory power and a reaffirmation of the need for procedural integrity in making significant amendments to environmental regulations.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.